Right, it's 1 o'clock. So welcome to everybody present during this panel discussion. I'm Professor Richard Stevens, as you know, and I'm glad to see the number of participants that we have today. I'm glad to see all my students, although they may argue that they are here under duress with the sword of possible exam and test questions hanging over them. But hopefully they will enjoy the discussion, given that we just at 12 o'clock started with the corporate governance section of the work, and I gave them a bit of a taster of what they may expect. Now, I think I'm not going to repeat what everybody has seen on the introductory slides. I think what is very interesting, though, and despite two of our panel members having links to Old Mutual, I don't know if they're going to address this indirectly in their answers later. I see in today's News 24, Investec launched its Global Sustainability Equity Fund for South African investors yesterday. And it says here, Investec has, if I can quote, Investec has launched a global sustainability equity fund that the finance house says looks beyond companies' ESG, i.e. environmental, social and governance scores, to focus on their negative impact on society. The fund prioritizes investment into companies that are doing good, and more particularly, those doing their bit to help the world move closer to achieving the United Nations 17 Sustainable Development Goals, or SDGs. Now, although the fund includes mining stocks, which already begs the question, how do you reconcile mining stock with sustainability? I think also, as part of introduction, the Securities and Exchange Commission in the US a few months ago requested public participation by posing 15 questions in terms of companies' responsibilities in respect of carbon emissions, not just their own direct carbon emissions, but also the supply chain. So whether what the type of energy they use, the products they make, but also further down the supply chain, how there's an impact and what disclosure would look like. You also have the EU, not just looking at listed entities, but also looking at alternative investment funds, like, for example, private equity funds and their disclosure requirements. So ESG, transparency, disclosure, greenwashing are not just buzzwords these days when it comes to reporting. It actually is going to become more and more real if one especially considers the IPCC, or the Intergovernmental Panel on Climate Change report of last week, which basically says that the Earth is on code red, and how companies are going to respond to this challenge in the long term. So these are the vexing questions that a lot of company law lawyers, but not just company law lawyers, but society as a whole, are busy questioning, not just governments, but especially companies, given the power that especially multinationals exercise in the global economy. With that said, I want to welcome my panel, who will discuss these difficult issues today with us. And I'm going to start alphabetically. So first of all, we have Professor Irene Marie Esser, who's a professor of corporate law and governance and deputy director of the postgraduate teaching at the University of Glasgow. She did an LLB here at Stellenbosch. I think I still taught her, which shows my age, unfortunately. But it's glad to see that Irene Marie has gone so far with her research, and her focus is, she was an extraordinary professor at UNISA, and she currently is also an extraordinary professor at Stellenbosch University. So she's an admitted attorney in South Africa, and also her work has been referenced extensively in the King 4 report on corporate governance, following her inclusive stakeholder protection approach. Irene Marie also provides training on corporate governance on a regular basis to industry and also presents a workshop at the University of Johannesburg on board governance since 2009. She's also on the editorial board of the European Business Law Review and has been the company law convener of the UK Society of Legal Scholars for the past 3 years. And she's also recently been invited to act as an academic expert to a new accreditation service on ESG investing. So welcome, Irene Marie. I hope it is sunny in Scotland today. It seems though from the lighting that there is some form of sun. Then next is Mr. Robert Lewison from Old Mutual Investment Group Responsible Investment. And he's been part of this team since 2014. We will not hold the fact that he has a B Business Science LLB from UCT. We will not hold it against him, so we will excuse him for the error of his ways, but he was probably young and didn't have any choice in the matter because he probably would have come to Stellenbosch otherwise. But be that as it may, welcome, Rob. So Robert is responsible for proxy voting and engagement, representing Old Mutual Investment Group on various industry bodies and championing responsible investment for the Old Mutual Group. And as I've just referenced to the News 24 article of Investec, Rob will probably have interesting perspectives on industry and that in that regard. So Rob's got a legal and corporate governance background, so he can bring his knowledge of law, but also the softer skill of negotiation to the fore in promoting clients' interests. And prior to the responsible investment team, he was a legal advisor at Old Mutual Investment Group for 7 years. So he has 14 years of work experience in the legal profession and asset management industry. And as I said, he's got a B Business Science LLB from UCT and is an admitted attorney. Next, we have Professor Ian Mcneil, also from University of, he was appointed to the Alexander Stone Chair of Commercial Law in 2005. He was initially an investment analyst in the City of London during the 1980s, covering the insurance sector. He then took up his first academic appointment at the University of Aberdeen in 1993, following the completion of his PhD on the legal framework for the EU single market in insurance. So Ian's primary interest and expertise now lies in corporate governance and financial regulation, and he's published widely, and in particular he's explored the interaction between public and private law in this sphere, as well as the influence of international standards. In 2012, Ian served as a special advisor to the House of Lords EU Committee for the investigation into MiFID II, so that's the Markets in Financial Instruments Directive 1 and 2. And then in 2014, he served as a member of the UK Research Evaluation Framework Panel for Law. He's also the Deputy Chair of the 2020 Hong Kong Law Panel and the 2021 UK Law Research Evaluation Framework Panel. And he has served as Senior Advisor on several EU projects relating to finance industry. Then second to last is Ms. Ansi Ramalho. She's a lawyer by training and considered a leading authority on corporate governance with both deep and broad theoretical and applied knowledge on the topic. She chairs the King Committee on Corporate Governance for South Africa, where she has served for more than 12 years. And she also serves as a professional non-executive director and has been conferred the Chartered Director designation by the Institute of Directors. From August 2014 to November 2016, she was appointed as the King 4 project lead with responsibility for the successful finalization of King 4 on corporate governance. Then last but not least, we have Emeritus Professor Andreas van Vake, who taught me private law in my first year and was also my supervisor for my doctorate in company groups. Born in 1941, he trained at Stellenbosch and the University of Bonn in Germany, and he obtained his doctorate cum laude from the University of Leiden in the Netherlands. He also in 1997 received his honorary doctorate in law by the University of Leuven in Belgium, and also from Stellenbosch in 2013 for recognition for his service to the higher education sector. He's not just an academic though, he's also very familiar and involved in company boards, because he was on the board of Boland Bank, which was eventually served through various companies into Nedbank, distillers locally before their merger with Stellenbosch Farmers Winery. And he was also chairperson of Old Mutual South Africa, where he was a non-executive chairman of the board until 2008. And after his retirement as rector of Stellenbosch University, Prof. Van Vake returned to teaching, where he taught with me, or often for me, the elective in corporate governance, and also served as supervisor for a number of doctoral theses, whether on insider trading or corporate governance. So welcome to all my panel members. Now, the nature of this is going to be that I'm going to pose a number of questions to the panel, to which they will respond. If you have any questions for the panelists, I'm going to ask you to post your questions in the chat until 10:02, where my assistant will collate any questions, and we will then let it thematically and let it stand over for the last 10 to 15 minutes between 2:15 to 2:30. So we will not, the panel and I will not monitor the chat, but someone will be monitoring the chat if you have questions which you want to raise. And as Mr. Smith indicates, where to ask your questions. So we will then address those questions, if any, towards the end. Right, so if we can start off, I think I'm going to start off with Irene Marie, because the panel discussion was her idea, and I think I'll give her the first opportunity to get going. So Irene Marie, with the introduction that we've provided now, and where the world is going to, if you think of Enron, you think of the 1990s or 80s where financial reporting was core. If you see where the world has been moving to in terms of broader stakeholder theory and the interested parties in the company's operation, whether it's the environment, whether it's the community, whether it's a society at large, or employees or creditors, what do you think the role disclosure plays? Is it a reliable mechanism to promote this variety of stakeholder interests and to get them more engaged and involved in board decision making?
Yes, thank you, Richard, and thank you so much for the kind invitation and for all the panel members joining us today. I'm really looking forward to the next hour or so. So with regards to your first question, I think it is true the importance of disclosure has risen to the fore in recent years. Non-financial reporting has risen significant in recent years, as the role of stakeholders who are not shareholders has been recognized in corporate governance frameworks. So this plays an important role, but it is not without limits. During a few years ago, I did a study with some of my colleagues at the University of Glasgow, where we looked at the reporting of the FTSE 100 companies in the UK over a period of 3 years. And we specifically looked at the quality of non-financial reporting and the extent that non-financial reporting facilitates stakeholder engagement in corporate decision-making. And we found that non-financial reporting requirements is very high, amounting even to super or over-compliance. We then also looked at the quality of the non-financial reporting through a series of interviews with stakeholders to determine whether the current regulatory framework on non-financial reporting in the UK informs stakeholders adequately so as to facilitate effective engagement in corporate decision-making. Now, even though this was based on a study in the UK, it is definitely of significance for other jurisdictions, including South Africa as well. During this study, we observed some interesting facts. For instance, that according to the participants, the main reasons for disclosing non-financial information are often, according to them, purely compliance, whilst the genuine interest in ESG matters is almost at the bottom of the list. Participants argued strongly that disclosure of non-financial information is not enough, and stakeholder engagement and participation methods are indeed needed. And this is sort of the part that we really focused on the most, and we are proposing various mechanisms in this context to assist. So our main finding or main point is really that even though disclosure is important, obviously it provides information, it can have an impact on the reputation of a company, it is often not sufficient on its own. It is only one way to protect stakeholders, and its aim is to keep them informed. For proper engagement with stakeholders, much more is needed. The prioritization of shareholder value and the lack of focus on stakeholder interests could be the main reason for the lack of engagement with stakeholders, and this needs to be addressed. So as we know, globally, there has been a lot of focus on non-financial reporting or integrated reporting, like in South Africa, in the form of soft law, operating, for instance, in the UK on a comply-explain basis to a certain extent. Sometimes it's linked to listing requirements, or like the strategic reporting in the UK, it's based on hard law in certain instances. So even though the UK is characterized by a flexible system that operates on a comply-explain basis, I am of the view that this is not sufficient in this context. There is no mechanism for market discipline available to stakeholders that's similar to the selling option available to shareholders. And therefore, the rationale for comply or explain is weaker in this specific context. So what other mechanisms can we think about in this context apart from disclosure? Well, a mandatory committee considering ESG issues would provide a level playing field for stakeholder engagement. And in this context, we often use the Social and Ethics Committee in South Africa as a really good example and sort of a way to work towards. There is still scope for soft law mechanisms, and here I can refer to provision 5 in the UK Corporate Governance Code dealing with workforce engagement mechanisms operating on a comply or explain basis. And this provision in the code indicates a shift to a more explicit process for the integration of stakeholder interests and a move away from reliance on disclosure as the primary regulatory technique. Other things that one can consider in this context is say on purpose provisions, linking ESG to remuneration, but reporting and even more procedural elements like a due diligence requirement or a board committee should definitely be embedded through hard law. And as I said, in South Africa, the Social and Ethics Committee, as well as integrated reporting, is quite relevant in this regard. Thank you, Richard.
Well, if I can follow up on that, it's interesting that you've now focused on these soft law approaches, and it's interesting that you didn't mention the word accountability, for example, because, and especially if you hear what Investec now has just said in this article that I read this morning on News 24, where it says, and I quote, we will look beyond the company's ESG scores to focus on their negative impact on society. So in that sense, it begs the question, isn't this just a tick box exercises? Because unless disclosure leads to accountability, and if you think of traditional company law rules like the reflective loss principle, and you think of the 3 cases last year in quick succession, you had the House of Lords decision in Sevilla, where the courts confirmed this reflective loss, where unless it is the company suing the director, even if you are a shareholder, you can't bring any cases. Then you have the Steinhoff certification judgment in May of last year, where the Judge Unterhalter effectively said the same. And then a week later, the Supreme Court of Appeal in Schlumisa also confirmed that this reflective loss principle, that it's the company that is the primary plaintiff, in cases. That sort of like makes you wonder, it's all good and well having a stakeholder interest approach, but unless there's going to be a form of accountability, isn't accountability ultimately what we are striving for, and how does one achieve that?
Yes, so I think that is a very good question, and it is indeed something that we considered in quite a bit of detail. When you consider stakeholders, when you look at ways to protect stakeholders, ultimately to have a more sustainable company in the end, do you focus on directors' duties? In other words, typically in the UK, you're looking at Section 172, and in South Africa, Section 76 of the Companies Act. Do you think that reform should be done in that context? In other words, in the context of directors' duties? Of course, that leads to various problems that we are all aware of. It's very difficult to have directors' duties to all stakeholders. That's why in the UK, they still follow the enlightened shareholder value approach, and in South Africa, it is still very much based on Section 76 shareholder value, although other provisions in the South African Companies Act are much more closely aligned with stakeholder protection, like the Social and Ethics Committee, the purpose provision in the Act, and so on. And then you get the problems of enforcement in that context. And I think that is why we have proposed a sort of not a different model really, but a model where we do not propose reform with regards to directors' duties. We rather want to focus on sort of a set of mechanisms that can assist in stakeholder engagement and getting stakeholders more engaged. So to get back to your question, is increased stakeholder protection and engagement a way to increase corporate accountability? I think yes, disclosure plays a crucial role. But as I said, on its own, it is definitely not sufficient to improve stakeholder participation. For stakeholders to be fully engaged, they need adequate information in the form of disclosure, but they also need other mechanisms. So in this context, we've suggested, and I've done this research with Professor Mcneil, and we suggested an entity model of ESG. So for us, the focus is on the corporate track. Stakeholders can receive the best protection if their interests are considered during board decision-making. And we compare that to the investment track as opposed to through capital allocation in the investment track. When you read in the news, when you look at various guidance documents, often ESG is referred to in the context of investment, of risk and return. We feel that that should go back to almost the traditional CSR model that happens within board decision-making. So our proposed entity model of ESG suggests reform in this context to promote sustainability in the corporate sector more effectively, focusing on disclosure, but also stakeholder committees, linking ESG with remuneration, voluntary say-on-purpose provisions in the Articles of Association, and mandatory due diligence. And I think by following all of these various mechanisms, you can, to a certain extent, move away from purely box ticking that is often achieved by only focusing on disclosure.
I think before I move on to Prof. and Vake, I'm going to try and do something, and I don't know if the organizer will allow me to quickly share my screen. I actually want to show you a slide which I used and I discussed with you last night, actually, which I showed my class yesterday or this morning, and which ties into what you've just said. So I'm going to try and share my screen now and show you this following slide. I think, yeah, you can see it. Yes, the planet got destroyed, but for a beautiful moment in time, we created a lot of value for our shareholders. Now, I told my class this is not supposed to be funny. So although it's a meme, it's definitely not funny. Now, I think what that slide ever shows, and I try to address this with my class, is one has to distinguish your retail investors or your ordinary person in the street investor who doesn't really care about the short, long-term value of a company and where it goes, compared to institutional investors who have a longer-term view. If your pension fund is now currently with fossil fuels, you are going to be very upset if you look at now how Shell, in the recent past, how Shell has been told by the Dutch court of cutting carbon emissions by 2030. As an institutional investor, you do have that power. Now, how does one address this if you say that stakeholder interests, especially with shareholders and involving board policy, with shareholder apathy, is, again, I think it begs the question, unless it is retail investors, what power do sort of, unless you have institutional investors driving this, do shareholders really have this power? And if the answer is no, the broader stakeholder theory is probably the way to go to sort of enforce board accountability and how investments are made. I mean, would you, yeah.
Okay, do you want me to? I thought you were going on to Professor Van Vake. Apologies.
I think it will be a good link between the two of you. So what you say, I think Prof. Van Vake can actually continue, either on depending on what you say, or he can also answer.
Okay, so basically to what an extent does the variation in stakeholder interest and capacity for engagement limit their contribution to making corporate decision-making more sustainable? Yes, so as I said before, we focused on disclosure quite a bit already, and I think most people will agree that it is a good mechanism, but not sufficient on its own. And I refer to the ESG model that we are proposing in this context, and really the underlying premise of the financial model is that there is no clear or consistent obligation to implement sustainability at the entity or the operational level. So once that constraint is overcome, the principle of using the financial channel to drive ESG is no longer required, as all funding can only be channeled to entities that comply with such an obligation. So the financial model in its current form is an interim market-driven solution which responds to legal risk and is a precursor to a more systematic approach through regulation. So based on this entity model of ESG investing, which is really inspired by the earlier corporate social responsibility tradition, our model combines law reform with a residual role for soft law. As I mentioned before, obviously comply or explain principles still being very much of use, provision 5 of the UK being a good example, stewardship codes really, and the link with ESG in that context, but also through voluntary action such as purpose provisions in the articles, or say on purpose, if you like. So maybe then just to sort of a few final points, variation in stakeholder interest inevitably poses challenges for the integration of stakeholder interest. And I think, Richard, that is what you said before as well. So, for example, employee interests are already prioritized in the UK Corporate Governance Code, but that does not directly address the externalities linked with environmental protection and climate change, for instance. A more overarching approach is a duty of due diligence linked to sustainability. And that is where we are focusing on, rather than trying to reform directors' duties directly. Such a duty can be framed as a business process, so more of a procedural requirement, but it can also be framed as a standard of conduct where the focus is on discharging obligations that go beyond internal process, or maybe some combination of both, really, to prevent box ticking. So our proposed model would change the focus of ESG investing to focus more on stakeholders through the introduction of such a duty of due diligence, but also supported by a stakeholder board committee. So we view the focus on stakeholder empowerment primarily as a mechanism to drive internalization of externalities. While regulation, for instance, carbon taxes or import duties, might also drive that process, we see a role for stakeholder empowerment to contribute in terms of capturing the organizational and operational aspects of a business in more detail than would typically be possible through regulation. So finally, the focus of the financial model on the investment chain as the primary driver of ESG subordinates the accountability of the board of directors of companies for the operational aspects of ESG. Boards are less likely to lead on ESG development in a situation where they lack discretion because of the mandate that is transmitted through the investment chain, or where there is no direct consequence because of inaction. That in turn is likely to limit their capacity and inclination to drive internalization of externalities at the operating level to achieve real-world change. In contrast, the entity model locates accountability more clearly with the board alongside other forms of strategic decision-making, as previously mentioned. Thank you so much.
Thanks. Yeah, that's very interesting because I think that leads me to Prof and Vake. If one looks, and I think I want to leave ESCOM and SOEs rather out of the equation here because those are unique beasts with political pressure. But if one considers the South African landscape, if you look at Health and Racket, Masterbond in the late 80s, then Health and Racket in the early 2000s, you look at Steinhoff now, that sort of begs the question, disclosure in itself, how effective is that in respect of possibly corruption, unethical business? And if one looks at supply chains, more broadly speaking, in terms of modern slavery, effectively.
Thanks, Richard. This is fascinating. If you'd asked me 10 years ago whether I would go for the, let's call, traditionally British soft law approach, King 4, etc., or the hard law approach, I would definitely have said soft law, let's go for disclosure, soft law as the primary tool, and hard law as a sort of a fallback, as Ian Mcneil has been advocating. I don't know why, but I've changed my mind. And I think I've changed my mind mainly because of what's been happening in South Africa. With all the scandals we've been having in the area of state-owned entities, but not only there, but as you've said as well, with private sector scandals, corruption, I've started believing that we have to go more for the hard law approach. Why? Why do I advocate more and more doing American-style SOX instead of, let's call it, our traditional approach? I believe that there are certain fundamental changes taking place regarding disclosure. First of all, the weakening of the soft law enforcers, because there are enforcers in soft law. First of all, the media. South African media are declining in influence. Their readership has been going down, and you've been seeing much more noise in the social media than in the traditional press. So I think I should put it this way. There was in olden days, there was a hierarchy of media. You had the Johannesburg commercial press, you had the Johannesburg establishment media for the financial markets. They're declining in influence. I'm speculating, I don't know what the impact is going to be in this area. But are we going to have the media still as effective enforcers of soft law? Then secondly, and I hope I don't get shot for this, but we also have the decline of the financial markets. Look at South Africa. The JSE has been declining. It's been shrinking. You have all these delistings. And in spite of ANSI's best efforts in King 4, which I fully support, to extend the criteria in King 4 to non-listed companies as well, that is where the core remains. And you have the rise of alternative markets. You have the inherent conflict of interests at the JSE, where ex-student Nikki isn't there anymore, but where Nikki was fighting all the time to keep the listings, and thereby having a softly approach to enforcing the listing requirements. And that policeman has definitely become weaker compared to earlier on. and also the internationalization in this regard. Companies do their utmost to avoid American listings. Why? In order to avoid the stringent American requirements. And thirdly, linked to my previous remark, I'm afraid, in my view, the influence of voluntary codes like King, like the Combined Code elsewhere, has been declining because of these changing environmental factors. Then, my final remark in this regard, the auditors. This morning, I received for the first time, I wasn't aware of it, a new document emanating from IRBA. It's a consultative document, consultation paper on enhancing disclosures in the auditor's reports in South Africa, addressing the needs of users of financial statements. And it's a very, typically IRBA document, very auditing oriented, about what must be disclosed exactly in what circumstances, etc. But it's an approach basically more of the same medicine. And it's sad for me that 20 years ago in South Africa we had the impression that our auditing profession was one of the top professions in the world. Where are we now? They haven't covered themselves with glory in the last 5 years. These scandals in state-owned entities, scandals in IRBA itself, and these are supposed to be the institutions supporting soft law. And if you look at the UK as well, there as well the auditing profession hasn't been shining through effectiveness and ability to enforce these standards. Let's think of Carillion, British Home Stores, Sir Philip Green, and I can continue to mention all the other examples. So, where do we then go? And then I end up with hard law. Obviously, a judicious mix, as Ian Mcneil said. It's not a choice between only hard or only soft, but I'm moving more towards the hard law side. And we're talking about hard law, that of course presupposes effective institutions. And that's where, once again, as a South African, I have a dilemma, because that presupposes an effective, efficient public sector, whether administrative, judicial, or criminal. And do we have that? If we look at administrative, quite frankly, I think SIPSI, what do you still call it, SIPSI, the Commission, is totally ineffective. It really doesn't play any role. And if you compare it to, for example, overseas models like the SEC in Washington, it's really laughable how badly resourced it is and how ineffective it is. In the field of administrative, I would also include the special board committees, which are required by law, in our case, SEC in our sense of the word. And talking from my own experience, I think that was a very good move to introduce this obligation to have such a board committee, because at least it put these matters on the agenda. But I can assure all of you, from my own experience, it's always the last item on the agenda, and it's always manned or womaned, peopled by the less influential members of the board. That's the soft spot to put members of the board, not the real heavy hitters. So at least we have it on the agenda now. But I'm not convinced that it's really been making a huge difference. Then judicial, let's move to the courts as part of the mechanism supporting the soft law, the reporting requirements. I've come to believe that the only way we are really going to get serious attention being paid to these requirements, accounting requirements, environmental SEG requirements, it's going to be if they are supported by judicial instruments. Let's take Nigeria as an example. The Nigerian issue with Shell has been going on for 30 years. Nobody paid any real attention until the courts started getting involved, seriously changing their minds by using these sort of principles underlying German Konzernrecht, meaning that you cannot hide behind your separate judicial legal entities saying I'm not responsible for the deeds of my subsidiaries. Therefore, looking at South Africa, where have we started seeing some due diligence, some responsibility, has been through the application of Section 162 of the Companies Act, being declared delinquent director. Dudu Myeni. The Dudu Myenis of this world wouldn't have done anything if it hadn't been for this threat of exclusion and personal liability. Same applies to Section 22 of our Companies Act, where you pierce the corporate veil for reasons of unethical behavior, etc. Therefore, to summarize really my conclusion at this stage, I don't like the American background of our new Companies Act at all, but I do think we should learn from SOX, in particular, Sarbanes-Oxley, and particular Section 302 and Section 404. Section 302, for those who don't know the provisions by name, is very simple. It says, the Commission, that's the SEC, shall require each company filing its quarterly reports with the Commission that the principal executive officer or the principal financial officer certify in each annual or quarterly report under such section that the signing officer has reviewed the report, that based on his knowledge, the report does not contain any untrue statement. 3, based on his knowledge, the financial reports fairly present in all material aspects the financial condition of the corporation, and etc., etc. Those two role players must personally certify the accuracy of those reports. Then finally, 404, the most controversial of these provisions because it has the highest enforcement costs, the highest costs for enforcing this, and it's been calculated that the average listed American company spends about $1.5 million annually on enforcement costs in this regard. Section 404 saying that the company must inform its auditor of the existence of proper control systems in the company. And the auditor must report that report to the SEC. So there is a duty to have proper control systems. And all of this, very nicely American, is reinforced by some hefty criminal penalties. $1 million for false certification, or 10 years in one of those nice American jails. Or, if there's willfulness involved, 5 million or 20 years in jail. Now, these are hefty penalties. And I just want to come back. Unfortunately, Richard, our little town, academic town, has become notorious in South Africa as the seat of Steinhoff and as the seat of corrupt capitalism. Totally wrong, of course, nevertheless. If we take Steinhoff, what happened with Marcus Jooste when he appeared before Parliament? He just said, I didn't know about this. Now, nobody believes him, of course, but he can start such an argument. In America, it wouldn't be possible. And we have to keep it simple. And there I just want to stop. We have to keep it simple because our prosecuting authority has no capacity, has virtually no capacity in matters financial, in matters commercial. So there are enough problems with fighting our ex-president. So if you want to make it possible to have criminal remedies, you must make it as simple as possible. And this is the case. I think that's what I wanted to say. Richard, over to you.
Thanks, Prof. I think that leads us actually nicely, given that Prof referred to Ansi's role at King and his view now on soft versus hard law. Ansi, do you think that with this move towards more mandatory rules, especially in respect of non-financial reporting and the way the EU is going, also, do you think there's still a place for soft law?
Richard, yes. I think that as Prof van Vake has said, it's not only one or the other, but I think what is important is how the two are interacting. So hard law is very useful in that it's very definitive and that it's often a quicker measure than soft law. But it also has its shortcomings. And the first shortcoming, which I very clearly want to point out and about which I feel very strongly, is that it's not the panacea for all ills. And what I mean by that is that if we use Steinhoff as an example, it appears that there has been fraudulent report. Well, I think it's been established that there has been fraudulent reporting if you look at the results of all of the investigations. Fraudulent reporting is unlawful, but the law did not stop it. If we look at our municipalities in South Africa and the qualified audit opinions that they're getting, the findings from the Auditor General on fruitless and wasteful expenditure, I mean, all of that is unlawful, and yet it happens with impunity. Fraud and corruption is unlawful, and it happens. So I think we should be careful in seeing hard law as the solution, and I don't think that is what is said here. But it has its place, and I agree that hard law must be stepped up. I think we have relied to a too great extent on the soft law aspect. where hard law, where the soft law for me can still play a very important role is that soft law doesn't have the limitation that hard law has, in that hard law by nature addresses the minimum requirements. Soft law is by its nature again more suitable for aspiration. The hard law is almost the form, and the soft law you can almost see as the substance. I'm also a firm believer that if you implement the hard law without the aspiration, the aim, the purpose of the soft law, especially in a governance context, you're very likely to fall into a box-ticking trap, and it becomes about form rather than the actual intent behind it, the ethical intent behind it. The other issue that I also have is that our regulators are not the only, you spoke about accountability earlier, Richard. Our regulators are not the only bodies that hold accountable. Prof. Van Vake referred to the media. It's the other stakeholders as well. Of course, your shareholders, that one is evident, civil society, employees, and all of the such. But of course, that presupposes that you have an active stakeholder cohort. I still believe that stakeholder activism, of course, especially shareholder activism, but stakeholder activism more broadly, can play a very important role in holding companies accountable. You mentioned Investec, Richard. I think it was last week at its AGM that Investec asked its shareholders to give it a direction on how it will deal with greenhouse gas emissions in the way that it considers investments and financing. That resolution passed with a 99% adoption rate. I think what becomes one of the big levers of soft law is the reputational aspect. Social and market forces, I think, are underestimated compared to legal forces for the power that they carry. Social forces, the reputational aspect, the trust of your stakeholders, the legitimacy that you have in the eyes of your stakeholder, it carries a lot of weight. I would argue that loss of reputation in many instances are worse than legal consequences. Your social license to operate is as important, if not more important than your legal license. And then, of course, your market forces, where investments happen, where there's a flight of capital, also a very important lever. So, in conclusion, I would say both of those have a role to play, a complementary role to play. I do agree that we should shift more towards the mandatory aspect. Just one last aspect, Richard, that I want to mention as regards soft law. Soft law is very often and often finds its way in a very surreptitious way into hard law. What I'm referring to here is if a court has to consider whether a director acted with care and diligence, soft law will often be used as a reference for the court to make that call as to whether there was a breach of duty, a breach if due care was exercised or not. If you look at the developments the new regulation proposed by the European Commission, where there's such a prominence of sustainability considerations, I think that will lift sustainability considerations, and with that, shareholders' interests to the same level or equivalent level than shareholder interests. And those directors and those investors who fail to consider ESG risks, sustainability considerations, could very well be found even in jurisdictions where the European regulation does not apply, could very well be found to be in breach of their duty of care, because it is so out there and such an overwhelming surge of sentiment towards that. Thank you, Richard.
Actually, it's nice that you just mentioned that, because I was wondering, if you look at the EU currently, and if you could be brief, please, the EU seems to prioritize the financial sector or to investors, for that matter, in driving the corporate sector towards sustainability. Mm. I think you sort of now compared it to South Africa, because I think I'm going to ask Rob later about CRISA. So not necessarily referring to CRISA right now, but you think in a sense that this should be the financial sector's responsibility, like the EU is doing. Is that something that we should learn from the EU?
Yes, I think it's a very powerful tool. Shareholders and the financial sector often hold the leverage in this regard, which sometimes the other stakeholders are lacking. I think shareholders, especially institutional investors, often act as a proxy for the interests of other stakeholders as well, and ideally that's where we want them to position the exercise of their rights, being understanding in the spirit of Ubuntu that we're all in this together, and that if society suffers and the environment suffers, we all suffer, including shareholders in the longer term. So that's ideally where we want shareholders to focus their efforts on the long term, and more broadly than just narrowly financial. We know that the non-financial indicators are often leading and predictors of the financial performance. So it actually makes good investment sense as well. And that realization is now clearly dawning, I think. Yes, and in South Africa, I mentioned the example of Investec. Standard Bank recently at its AGM was grilled by shareholders on its stance on fossil fuel financing and on the potential human right exploits in oil and gas projects elsewhere in Africa. And so I think that's firmly the direction into which things are moving. Just an interesting detail about King 4 that I think has gone a little bit under the radar is that Principle 17 of the King 4 report provides for institutional investors exercising their rights and powers in such a way that they promote good corporate governance and sustainability. And of course that comes from the fact that there was an appreciation by the King Committee that you have to link board duties with the accountability role of institutional investors. It's only when those two work in tandem that you can progress corporate governance and that you can progress sustainability considerations significantly. So yeah, I do think the EU is on the right track. I do think that that is the lever, and if we're talking about hard law, definitely that is the lever to use. I still think that, and Irina Marie referred to it, I still think that there is room for our other stakeholders to become more involved. We've seen now with employees, with SAA, it was actually an employee union, an employee representative that brought the application for director delinquency. That's wonderful to see. Shareholder and the financial sector's power in this regard should be supplemented with these other stakeholders also playing their role. We all have a responsibility.
Right. Thanks, Ian. Thank you, Ansi. If I can move over to Ian. Ian, I think if you ask me, as Prof. Van Vake said, about 10 years ago, we would all be talking 10, 15 years ago about CSR and corporate social responsibility, and the more cynic in me would say, well, we're only going to invest in corporate social responsibility because it's good for our bottom line eventually, because it makes no sense to invest if you don't fulfill your social responsibilities, if the media is going to name and shame you in terms of where you source your products from, what your supply chain looks like. When you now look at ESG, do you see ESG and CSR as synonymous? Especially when you think of corporate decision-making and accountability, or are they two totally different concepts?
So thanks very much for that question, Richard, and it's a real pleasure for me to participate in this panel. I think I'd sort of start off by saying that ESG is really focused on risk and return in terms of portfolio investment. It's essentially a technique to improve returns by de-risking the portfolio. That's the history of the emergence of ESG. And we can contrast that with CSR, which is and traditionally has been more focused on the ethical dimension of corporate behaviour, and in the context of sustainability, which has become the dominant paradigm nowadays, that has meant internalising the externalities that are typically linked to corporate activities. So, and sort of linking back to some of what Irene Marie said, ESG is about decision making in the investment chain relating to the supply of capital, and it's the supply of capital which is envisaged to change corporate behaviour. You only get new capital in principle for green or ESG compliant projects. Now, of course, that's a different paradigm to CSR, which has traditionally been focused on operational decision making within companies themselves, not within the investment chain. Why has this change occurred? Well, I think one reason you can say is that investors have engaged more with ESG than they did with CSR, on the basis that ESG can be framed as a benefit, translating into higher shareholder returns, whereas traditionally CSR was viewed as a cost, as you hinted in your introductory remarks, Richard. So one of the ways that we sort of characterized this sort of contrast in our paper was to say that, when you look at sustainability as an overarching concept and attempted to link it with CSR and ESG, you could say that really what you had was a trilemma. In other words, you had three options, but you could only choose two, and one of them's got to be sustainability. So what we said was, with sustainability, you can fit in CSR or you can fit in ESG, but you can't do both at the same time. You could try, but it's ultimately there are tensions between the two that that mean it's not going to work. Looking beyond that, our sense in that paper is that the shift in focus over time from CSR to ESG has likely diluted board accountability, as the ESG model means that they lack responsibility for initiating CSR actions. In other words, they've given up that responsibility to the portfolio managers. Now, this carries implications also for the integration of CSR or ESG with operational activity, as portfolio investors lack the information and expertise to make operational decisions. And, ask any investment manager, they'll tell you, we're not interested in making operational decisions because that's not the business that we're in. So, in some ways, the emergence of ESG and the implicit subordination of CSR in corporate decision-making demonstrates the capacity of markets to outmaneuver law. The move to ESG was largely driven by capital markets, with CSR being reframed in terms of a model that would improve investment returns rather than create costs. Now, of course, there's a challenge implicit in this, because sustainability is framed as an overall cost for society. So there's a kind of element of financial alchemy if we attempt to map that cost, if we attempt to map sustainability onto the corporate sector, and then we claim that actually there's a net benefit in terms of the characterization of the process that we're engaged in. And, I would say some companies are now beginning to recognize this. In other words, they're beginning to say, hang on, ESG is a risk to us and represents a cost. It's not just a new investment opportunity that will create gains for us. But I would say we're only beginning to see that probably in the last year or so, maybe even in the last few months, we're beginning to see companies coming out and say that. And how that plays out is going to be interesting. In other words, we've got this fundamental question, what is ESG going to do? Is it going to create costs and better returns, or is it going to be something else? And linking back to some of what Ansi had said, of course, reputational effects are playing into this as well, and we shouldn't ignore the demands that are being generated in product markets. We've been talking about the operational side and about the investment sector primarily, but of course we can see the product market generating demands in terms of supply chain integrity, the quality of products, how they're made, who they're made by, what these people are paid, and all this exerts pressure in terms of the development of ESG. But to kind of round up my comments and to focus specifically on your question, Richard, what is clear, despite the uncertainty as to how things are going to play out, is that ESG, as we stand now, has evolved into something that really is quite different to what we knew CSR to be in the past.
Thanks, Ian, for that. And it's actually interesting that you mentioned, because I think also what I've read recently in the EU, and I don't necessarily have to answer this because I actually have a different question to you, is the idea that one of these days you're probably going to have a CSO, a Chief Sustainability Officer, or whether it will be incorporated into the job description of a COO, CFO, or CEO, or whether you're actually going to move towards having a CSO and what the responsibility of that's going to be, if that's going to be risk management or not. But I think my question is rather, when you look at now environmental or social or governance, does one stand out? And if you speak about sustainability, it's sort of immediately you sort of think environmental reporting or disclosure or investment is probably the standout one. Do you see it as such, that the E is the most important, or not?
I think you're pretty much right to identify that trend, Richard. I think the the ESG, to my mind, has definitely been in the ascendancy in the development of ESG. So if we look at the development of the green taxonomy in the EU, or the Task Force on Climate-Related Disclosures, the TCFD, at the global level, with the FSB developing those standards, I think they give a sense that the environmental dimension is the most significant. And in a way that links to the focus of ESG as a portfolio technique, because I think the concept of mitigation and risk reduction maps best onto the E of the ESG trilogy. The S, the social dimension, has been associated much more with soft law. So we would think about the UN Global Compact, the UN guiding principles. And I think there are much more substantial questions around effective implementation, and whether soft law represents an adequate mechanism, albeit that, of course, reputational effects are proving to be quite significant. And sort of, rounding that up in terms of, what is the role of governance in all this? So, in a sense, we could say that, the governance movement was actually running ahead of the E and the S, because, if we look back to the start of the governance movement with the Cadbury Code in the UK in the early 90s, that movement was really well established and quite well entrenched by the time we got to, say, 2005, and we had the PRI principles being initiated at the international level. So, we kind of had the governance dimension making the early running. It was then, to some extent, I think, superseded by the environmental, a little bit by the social, and I think what we're seeing now is a kind of rounding up of concluding that actually, if we're really going to embed ESG effectively within investment and corporate decision making, good governance within both tracks is really essential to that. You're not going to get anywhere with any of these propositions unless you've got good governance in place. So I think in that sense, what you can say is that good governance is the kind of central underpinning of both of these dimensions. But, for my money, if I were looking ahead for the next few years, I would be saying that the environmental dimension has the stronger trajectory. We'll see more development there, I think, in terms of hard law. That's already happening, for example, in terms of TCFD reporting being implemented as a hard law obligation. And whether we'll see, parallel development in the social dimension, I'm more doubtful about, because I think it's there that the cost dimension of ESG is really located, and that's a more problematic issue to really get to grips with.
Yeah. Thank you for that, Ian. I can move it over to Rob because it's actually very interesting that you talked about investment, and that's obviously what he does at Old Mutual. Rob, when you hear about integration of ESG into the investment decision making, do you think institutional investors have developed credible and scalable techniques beyond screening and exclusion?
Well, thank you, Prof. Richard, and thank you to my co-panelists. It's been a super interesting discussion with plenty of interesting points made, and lots of, as the last speaker, I guess, have the benefit of all your various insights into this. So firstly, to come back to your point, Richard, about being an IKE, yes, very much acknowledge that, but do have a very strong working relationship with the University of Stellenbosch over the years in the School of Management Studies and the Centre for Corporate Governance and many other institutions within the campus. And congratulations on 100 years. It's quite an achievement. So the first point that I'd like to make when reflecting on what has been said thus far is that there has been a fundamental shift in thinking around ESG and responsible investment. I'm thinking, if I take Prof. van Vake speaks about where we were 10 years ago, I reflected on my own experience coming out of law in 2014, in a sense, not turning my back on the profession in inverted commas and moving into this new realm of as a governance and engagement manager at Old Mutual Investment Group. I didn't know what that entailed exactly. I'll be quite honest. It was a new role. It was non-existent before in Old Mutual's history. I had my experience of working very closely in my legal career on our development impact funds, our infrastructure funds, our renewable energy funds, working on all aspects of the debt and equity matrix to drive investments into a development fund economy. And that started with our with the REAP program, our housing impact funds and schools funds in the early 2010s. And I had a feeling that there would be more to do here. We have the privilege of having a patient long-term capital behind us in the investment group. I know that I'm aware of many hats as an employee, as a pensioner, or not a pensioner, but a contributor to the Old Mutual Pension Fund. And all of these were being invested in various types of asset classes that are related. And I thought to myself at the time, isn't there more that we can do here? And certainly isn't there more for myself personally that I can do more than being a facilitator of concluding legal agreements and understandings. And I saw a lot of the fundamental ESG principles that are coming through actually being enshrined in terms of our constitution and having those play out in developing legal agreements in the investment world. So what did I do? I decided to take a new journey, and I decided to look into this area of ESG. Coming very much from a legal corporate governance background, it wasn't a problem. I knew our Companies Act inside and out, and I could very much talk to the proxy voting at AGMs, which was very much all governance related back in those days, and didn't have any other. It was more of a quick let's vote everything, and then there we go. Let's go have a drink afterwards. In those days when it wasn't virtual. Now and further to the point, I mean, I had to get up to speed very quickly on environmental and social issues that I knew and inherently felt very strongly about, but also were very keen to see them actually how they play out in terms of investment decision making. And at the beginning, it was a simple matter. We used to take our thinking to the investment teams. We sat in a little silo on the side, and we used to take our views to them, and they would simply say, nice, interesting, but I don't have time for this. I've got investment decisions to make based on real data, on track records, on investment information dating back years. And time and again, we kept coming up with the same the same glass ceiling, which I used to bump into all the time in trying to help the investment teams understand that these ESG considerations are material to the way they fundamentally make decisions about investments. It was only because of the likes of controversies that we had in various matters, and from Volkswagen to Steinhoff and the like, where the investment team started to pay attention, because we were ringing the alarm bells and saying red flag here, red flag here, red flag here. And, in certain instances, we made the right decisions. I know that because, how we divested from Able, or didn't invest in Able at the time, when that scandal was happening. And even in the Steinhoff scenario, it was a matter of we're not 100% comfortable here. So it's just nie reg nie. but maybe there's a little bit more upside or whatever the case may be. But we've gone from that to firstly being able to, and we talked to disclosure. Disclosure 6, or when I started, was nowhere. Even in emerging markets specifically, even South Africa, which had a really strong financial reporting framework and a good governance framework, integrated reporting wasn't really there yet. It was a whole lot of company waffle and not very much of what is linked to the material factors here. And nor was it assured or audited in any particular way. So basically companies could say pretty much what they wanted. So in terms of reliance, we had to do a whole lot of our own digging. We had to do a lot of our own proprietary screening and understanding of what the key and material issues are in relation to the companies that we invest in. And we proposed and created a framework that makes sense. And in addition, we then had a deep discussion with our investment teams a few years ago already about what are the key drivers within their process that we can feed into in terms of bringing in the relevant and material issues that drive investment behavior. And since we have had those discussions and had that thinking, we've been far more effective, in my opinion, about avoiding the pitfalls that come with investing into companies that have poor ESG characteristics. So on the one hand, I've seen this amalgamation of investment belief with ESG integration. That's on the one side. And on the other side of the investment decision is the post-investment decision. Well, you've invested in a company for various reasons. What do you do with that investment over the time? And I would argue that, and we come back to stewardship, I would argue that it is very much part of our fiduciary duty to our clients to be an active steward and not an absentee landlord in respect of their investments which they've entrusted to us. Not only that, but what we've been able to evidence, and again with help from the University of Stellenbosch School of Management, was that having seen the 5 years of my stewardship activity in relation to proxy voting, engagement with companies around material ESG issues, does that have any impact on financial performance and other forms of performance? And we see that actually the results of that study have been published internationally, I might add, by Prof. Vivius and Dr. Mans Kem, who've actually had that piece published in an international journal and have shown that there is a material correlation between what we do as stewards of clients' assets and the performance that results for them. So that's been backed up by other studies. There's a number of in academic institutions that I can mention. Elroy Dimson being one who was a skeptic who had been converted to a stewardship value add. And this goes to the points around, well, what is the cost of ESG here? Are we really saying that, to really truly integrate and think like ESG, that you can add a whole layer of costs and not derive any value? I would argue that is absolutely incorrect. And I would argue that it is absolutely incorrect that you sacrifice investment performance by integrating ESG considerations into your investment process, by adding layers of cost and complexity and the like. What we've seen is, in our opinion, is absolutely the opposite, and our clients are demanding those. And we'll come back to institutional versus retail investors, Prof, because you raised the point before. Our biggest advocates for creating ESG products, you mentioned the Investec product which is now on the market. Good luck to them. I think it's good to have additional competition. We have had our ESG indices and our ESG products in the market for over 5-6 years and have garnered over 30 billion rand of assets under management, which are covered by fundamental ESG considerations in the methodology of creating those products. We are also looking to realign some and launch some exciting new products to the market, but that's a whole different story for another day. What we have shown, though, is that there's not only the value add of of launching product and attracting a client's capital, and it's value additive. But also we have shown that stewardship in and of itself is value additive. Why have we done that? Because we have launched a separate listed equity stewardship service to the market for the very reason that you mentioned, this absentee landlord approach of shareholders in the past, where anything goes and you blindly follow management and voting at AGMs and speak softly behind closed doors and things will come right. We've long been advocates for speaking a bit more loudly and carrying a big stick, because we do have a significant amount of capital that is behind us. And we have launched a service to the market to help other asset owners where the real core of voting lies and the real power to exercise lies, and they've been silent in the past, or had their voices have been disparate in the past, have now come back behind a singular voice and go into the market and carry a specific issue that is concerning to them. Whether it be climate change, I mean, we haven't heard about COVID. It hasn't been mentioned once. Well, this is it's surprising. We're sitting here in a virtual panel from all parts of the world with 200 people in the room, and it's fundamentally changed everything. It's squarely put the focus on the fact that what happens in the biophysical system, in the social system, directly impacts the investment and the economic system. You can't divorce them. You can't separate them. Prof. Vake talked about institutions and the weakening of institutions. Yes, absolutely. What was the whole point of state capture? It's not just to capture the economy, but it's to weaken everything that will enforce or enable those that perpetrated those acts to be punished therefore. So the whole system was rigged for the last 10 years to do exactly the opposite of what we should be doing. I'm fully of the view that a harder law approach, given that soft law with weakened institutions does not have the impact that it should. I'm not an advocate of only hard law for the various reasons that Ansi has highlighted, but I think it's important and it's crucial for us to fundamentally close gaps that exist in order to ensure the more efficient and catch up really with the rest of the world in terms of closing those gaps. So you'll see a revised CRISA code coming to market soon. What that will mean? It will mean firstly it's a broad application.
Can I quickly interrupt you there? I think we're busy running out of time, but I think hopefully we can continue beyond 2:30 if people are present. I think we also are recording for those who have to leave us. I actually have a 2:00 meeting, but I rather will stick to this one. I already told the other meeting I'm not coming because this is much more interesting than sitting in a governance meeting of the university. But it's actually wonderful that you just mentioned CRISA. If I think correctly, CRISA, and for those who are not familiar, my students, that would be the Code for Responsible Investment, has been adopted 2011, 2012.
Yes.
So in a sense it's been quite forward-looking if you think back to the time. But do you think CRISA has achieved anything? You say now a newly amended CRISA. What do you foresee should the role be of CRISA?
Well, the role of CRISA at the outset was to, in essence, create a stewardship code for South Africa modeled somewhat on the UN PRI principles of responsible investment. It was aimed at listed equity. It was endorsed by those who decided to endorse and provide a disclosure every year on how they've applied the CRISA principles. But it wasn't. It hadn't any. We talked to accountability. It didn't have any accountable action other than, to say reputation-wise as an institutional investor, I endorse CRISA. And Yes, in many ways. I mean, it gathered some of the best minds around responsible investment and ESG in the country across all investment classes, and had, my experience of sitting on the CRESA as being a founding representative of the CRESA committee is that, a lot has been said, a lot of work has been done, and a lot has developed over time. We have just from the mere fact that Regulation 28 was also amended in 2011 to saying that trustees of pension funds must consider ESG considerations. We were the first in the world to do so. I know that for a fact. We have in turn linked up with an organisation which I also represented on International Corporate Governance Network, where the CRESA was an advocate for adopting a model mandate for investment asset owners to give to investment managers, which talked specifically to their duties of stewardship, and that was 2012. So along the time, we saw this rapidly evolving and developing thought process. Of course, Ansi and I worked hard, Ansi much harder than me, but certainly on the King 4 code itself, and we've spent lots of time debating via CRESA and via various forums into that specific document, giving feedback, giving our thoughts, and I think CRESA has done a hell of a lot over the last 10 years. What has been missing for me is two things. Number one, it has been only representative of listed equity. And number two, it's lacked enforceability. There's been no FSCA or any kind of JSE or IODSA or any oversight of those CRESA endorsees, CRESA disclosures from year end. And if you look in our mutual website, you can see our CRESA disclosures going back to 2012. It's not, but then, so what? It hasn't really been, no one's interrogated it. No one said, okay, well, this is in accordance, this is up to the standard that we'd like. And to my point, Prof. Richard, this was we saw as a CRESA committee, is 2 years ago an essential time, given where the world has moved to in the last 10 years, to revise and redraft. The stewardship code in the UK is binding, enforceable. If you don't do it correctly, you get kicked out as an investment manager. You you lose your license. That is a serious. I mean, they've literally tiered the investment managers. If you don't apply the code, the stewardship code correctly, you're out. In South Africa, that doesn't exist. And my view is that it has to be more broad-based, because I think there are strong and as strong levers of capital than listed equity in the market, like was alluded to. Private equity, fixed income, unlisted debt, carry huge say in terms of how investments in companies should run, and also in terms of what the cost of capital is if you get it wrong. So that's a topic for very much a topic for another day. But I would argue that enforcement is crucial, and to have teeth and have enforceability, and for members or signatories to the CRESA code to really have their disclosure scrutinized. I've said a lot, and it's just I'm happy to pause there. I might have missed one or two points in your question, Richard, but I would love to give the opportunity to the audience to ask questions and for any other questions from the panel. So thanks very much for your time, everyone.
Well, thank you, Rob. We've gone significantly over time, but I think it's such an interesting topic that I hope the number of people are still behind. We've only had 4 questions, and I'm going to pose them to them now, but I think maybe I'll first ask the questions and then conclude. And I think 2 of these questions are to Prof. Vake, and then 2 are more generally with 2 more general questions. So I'm first going to start with the other 2. The first question is, for countries looking to industrialize, how likely is it that they would keep regulations on accountability low in order to attract investors of some kind? And I think this probably goes towards multinationals and the power they exert. So I don't know who would want to answer that question. So anybody who wants to respond to that one.
Richard, if I could just off the cuff come in. There is competition, international competition in this field. On the one hand, it has favoured the creation of soft law because it's, if you want to be cynical, and I don't want to be cynical, it's a nice marketing instrument to say that you have King Code or that you have a Chroma Codex as in Germany, because it's expected from countries which want to try and attract investment to have those sort of frameworks or indications of good intentions. But on the other hand, I have no competition in the field of a low regulation. We all know about tax havens. And those tax havens are not only in the Pacific Islands, etc. They exist in the UK, the Channel Islands, British VI, etc., etc. But they're also regulatory havens. They're not only tax havens. And a place like the BVI, British Virgin Islands, for example, is a regulatory haven. It's the same way within the US, Delaware is a regulatory haven. And there have been efforts recently on the part of the big eight to try and deal with these issues. But there is definitely a competition to try and position yourself in such a way that you have a soft regulatory environment. That means that governments will position themselves if they want to, not only industrialize, if they want to have economic development, that they will try and go for these gaps. And that is an international challenge, which they're trying to address in the area of tax. For example, the proposal now worldwide of a minimum income tax rate of 15%. But to what extent we're making real progress in the regulatory environment, I don't know.
It's actually an interesting point because the second question follows on that, and you partially answered that. It's one of my students who asked the following: could tax law not have a significant role to play in the regulation of corporations' impact on the environment, either pecuniary or incentive-wise?
So, Rich, sorry. Ian, do you want to go? I just have one sentence literally to say here. Maybe I think you probably can then add to that just something brief on the taxes that I think I mentioned during my, when I talked earlier, is the role of taxes in the context of, ensuring more sustainable behavior. And I think I mentioned carbon taxes here, and obviously there's a role for those type of taxes to play here. But I think maybe, and I think this is a really good question, but maybe to link here is that those taxes can really usually only mainly address most of it the E level on the ESG. So it's, with carbon taxes, for instance, it's harder to do that with the S and the G. And also perhaps that taxes is not necessarily the only way, or you don't want taxes to be the only way to deal with this. You really want to have engagement on operational level, and that is something that, of course, you won't be able to achieve through taxes. So I just wanted to mention that with regards to that question.
Ian?
Yeah, I mean, maybe just to add to that, as well as for, what we might term direct or sort of Pigouvian taxes on particular activities that lead to environmental degradation, we could also add carbon credits, such as the scheme that is up and running in the EU, and there's a separate one developed in the UK whereby companies have to buy credits linked to emissions, and those are what you can see in recent years. If you look at the price of a ton of carbon, the price to buy a license to emit a ton of carbon has really rocketed in recent years. So there's some effect from that, but of course the challenge there is that even if in one substantial region like the EU, you take effective measures, you're perhaps missing out on some of the really big sources of pollution in other parts of the world. So, there needs to be more kind of concerted efforts on that front.
Yeah, thank you for that. Then I've got two more questions, both to Prof. Vake. I see from Inez Mars, former student of mine. Good to see your question, Inez. Prof. Vake, Inez asks, are we encouraged by the recent JSE listing requirement 3.84K change implementing CEO financial director sign-off on internal financial control as the, quote, South African version, unquote, of the SOX 404 disclosure controls you mentioned?
Yes, indeed I do. But that links up with one of my earliest remarks, and that is we're all in favour of King 4 listing requirements, etc., but their impact, as Ansi has said, is limited to listed entities. And in South Africa, we've had a vast range of delistings. Some of our biggest companies have delisted for a number of reasons. And that means that, as Ian has also said, unless you move beyond the listing requirements, you're not going to really make much progress, especially in an environment as in South Africa, where we're trying to encourage economic expansion outside the listed sector. So yes, good move, but not enough.
Yeah. Thank you for that. And then finally, also one of my current students, Mr. Da Costa, asked, Prof. Vake spoke of the collapse, quote, of the auditing profession and how this factor changes mind in respect of hard, soft law approaches. To what extent does the provision of non-audit services by auditors account for this, quote, collapse? And should we be looking towards audit reform as a hard law means of ensuring greater transparency and accountability?
Yeah, I want to link up with the recent UK developments, of which our colleagues will be very much aware, that the United Kingdom government has been looking at very intensively at the auditing profession in the areas where one expects them to look at, namely non-auditing work, not only the disclosure thereof, but the limiting thereof. Obviously, the built-in conflict of interest as well regarding appointments. Yes, there is a huge problem in this regard. And I don't know how one is going to really move in that regard unless one addresses, and I'm sounding now fairly left-wing perhaps, addresses the whole issue of the Big Four and their control of this market. Because a place like Old Mutual, Sanlam, wherever, they're huge organizations. They obviously want to have the best possible auditing services. So where do they go? They go to one of the Big Four. And that is an area where the EU had been moving as well, very tentatively initially. That big friend of the British, the chap who drove the Brexit exercise on behalf of the EU, he was the chairman of the commission to look at this a few years ago. And his recommendations were very clear about non-audit work, a total prohibition on non-audit work, for example. But it was lobbied out of off the table at the EU and never came into force. So this is a tough one now.
Yeah. Colleagues, I think it's time to conclude now and to wrap up. I think what we've seen today, and I think Ian summarized it really well in his session, of how we've moved, and I think everybody has spoken about it, how we've moved from accountability. When we think everybody was up in arms about executive remuneration X number of years ago as a name and shame, and holding executives to account and excesses in remuneration, to where we're going now towards more sustainability investment, and in a sense that sustainability and what role do investors play, and whether it's hard law or soft law, and which direction are we going to go. And that this is definitely going to be the theme for quite a number of years now going forward, and the most ideal form of doing so. Do you go the route of the SEC, but then you risk, as Prof. Vake has also said, that a number of companies will simply delist? And how are you going to regulate the alternative investment area, like private equity, which is probably one of the, still internationally, one of the most growing fields, where in South Africa it's still fairly limited. But given that the Regulation 28 and pension funds can invest in private equity, if one also considers, for example, that government has now proposed that up to 100 megawatts can be invested by independent power producers, now one would immediately think, as a cynical South African, that, oh my word, there's another chance for extreme corruption being available. It also is an investment opportunity if it is dealt with correctly. But again, if CRISA and responsible investment does not have any teeth, is the idea of where the EU is going with alternative investment fund managers and how they are regulated by new possible directives, where South Africa will be going in future, and that it ultimately comes back to investment and then also shareholder value ultimately. So whereas my slide said that yes, we destroyed the planet, but for a beautiful moment in time we created shareholder value, I think that slide will be turned around now with something more greener and say, but hang on, why didn't you invest in ESG companies where you could have shareholder value and have sustainability simultaneously? So on that note, I want to thank my panel members once more, Irene Marie, Ian, Rob, Prof. Vake, Ansi, for making the time available, for indulging Stellenbosch University, a law faculty, for nearly 2 hours of your valuable time. I really appreciate it. Irene Marie, especially for you, who were the driving force in doing this, for your alma mater and being extraordinary professor. So thank you for sort of keeping me on my toes and asking, when are we doing this? When are we doing this? Why aren't we doing this? Are we going to do this properly? So thank you for that. And colleagues, hopefully this is not the end of the road for us, that hopefully at some stage we can have similar discussions again, yes, and either with my students or with the people who attended today. And then for the people who attended, thank you so much for, I know a lot of you are in practice, and that you have sacrificed your valuable time to attend this. I hope from most of you in the financial sector or in the legal sector, I hope it was worth your while to attend. To my students, thank you to you too. Although, like I said at the beginning, you probably attended under duress, but the fact that 2 of you managed to ask questions, I hope that at least for some of you, if you found this very interesting. And in conclusion, I think I would hate to study B accounting or B accounting LLB these days, because the old days you only had to do IFRS or GAAP and you would just do financial accounting. Now if you want to be an auditor, you have to consider environmental, social, and how on earth, where I'm in, with all due respect and with lots of love, a number cruncher. Now I have to look at social aspects and environmental aspects. How on earth am I going to report on this in financial statements? So on that note, once again, thank you to everybody and a good day further to you.
Thank you, thank you.
Thank you, Richard. Goodbye.
Goodbye.
Thanks a lot, Richard.
Thank you all. Take care.